Welcome back again, but this time Magnet B is not around to introduce you into this, and I'll be the one to take you through this. Today I want us just to get into insight of what transcription is. I won't catch on the specific subject, but I will give an insight into what is required. First, the first question that people ask, what are legal files? Legal files mostly are done within the court setup, and we have got two main types of legal files, that are the deposition and the case legal files. What are the difference between these two types of file? In depositions, the judge is present, but the case is not yet established. The main idea of a deposition is to build a case so that they can be used into the main trial. In the case files, in the case hearings, the judge is present and the case is already in proceeding. We have got three main types of participants. That is, 1, a judge; 2, witnesses; 3, the different lawyers. Remember, earlier I told you there are two main types of lawyers while dealing with transcription. We have got the taking attorney. Generally, taking attorney are the guys we refer to as the prosecutors in our normal day setup in a court hearing. Then we have the opposing attorney, who is your lawyer in this case. So today, because I'm just giving you an insight into what is expected, I want to go deep into how to transcribe and the various modes of into which we format this other files of stuff. So today I'll capture so much on 1. When we have got more than 2 attorneys, how are we supposed to handle them? 2, when we got the judge, how are we supposed to handle them? 3, in the presence, in the sense that it's a deposition and the judge is available, how are we supposed to handle them? So this one will prompt me to discuss on 2 major types of event. But before I dig deep into this, at least I need to give you a reintroduction or an insight into what we discussed earlier. First, reintroduction. Remember, we have got colloquy and Q&A. The colloquy is a conversation between an attorney and a witness. The Q&A is the conversation between the witness and an attorney. Colloquy is any other conversation that is irrelevant to the main topic in discussion. So, the main subject of today is to give you an insight. In the event there are more than 2 attorneys and we divert into the colloquy, how will we treat them differently? How will you treat the event differently from the other event? How in the event there is a judge in the presence of a deposition, how will we treat it differently? So we have got to understand how we reintroduced. Normally, we reintroduce a statement in the event there is a transition between the colloquy into the Q&A, in which normally we'll use a title to indicate the mode of examination ongoing and the attorney who is doing the examination. Remember, legal files 80% is Q&A. So in the event there are more than 2 attorneys, we'll need to reintroduce the other attorney in case is doing the questioning. So how are we going to introduce? So I'm going to give you an example. Here is a case scenario. We have 2 attorneys present in a case trial where there is a judge. The attorneys will be asking the question. Normally, the first attorney to question the witness is the taking attorney. That is, we know him as the prosecutor, the attorney of the court. So by formatting will be Q, what's your name? A, I'm so and so. Q, are you there? Blah, blah. A, yes, yes. Then in between, the other attorney objects. Normally, when the second attorney objects, we refer to it as a colloquy, and we refer to him as Mr. and the surname. But what if he's coming into the play, is the one to question the witness after the taking attorney? Now, the opposing attorney is the one to question the witness after the taking attorney. How are we going to present this? So remember, it was QA flowing while the taking attorney is doing the questioning. Now in this case, the opposing attorney is coming into play. The main important thing is the reintroduction. How are we going to reintroduce this so that the client know that this is the person who is doing the questioning and this is the person who is answering? Remember, within the transcript, we have the QA format. But here is in a case scenario in which there are two attorneys. Now the first attorney is already done questioning the witness. The second attorney is coming into play. How are we going to bring this into play? How are we going to ensure that whoever is going through the transcript knows that the Q represents the attorney who was, the Q represents the taking attorney, or does the Q represent the opposing attorney? How am I going to know about this? How will the reader know that there are two types of attorney? Now I'm going to tell you how to reintroduce through that. Immediately, the prior attorney, the pre-attorney signs off before the next attorney comes into the play. He will be requested by the court reporter if he asks any questions contrary to those asked by the taking attorney. He will confirm, and he, if he's into play, will have to do a reintroduction. At least we indicate within the transcript that this attorney is the one doing the examination after the taking attorney. Now here we have the two attorneys. Now, how am I going to introduce the second attorney after the first attorney retires? So, I'm assuming we are already in the transcript file. The transcript files, we have got two main parts. The first part is the speaker side. The speaker side is where we indicate the speaker's names. We indicate when it's Q or A. In the event it's a colloquy, we will indicate if it's Mr. So-and-so. That is Mr. and the surname, if it's the attorney. But if Ama is the brothers, the witness brother, or is the deponent. Now, in this case, we have the attorney. The second attorney is coming into play. We need to do a reintroduction. So, in the speaker side, we write the word title. The word title. T-I-T-T-L-E in capital letters. In the transcript side, we are going to write the name of the attorney who is coming into play. The attorney who is taking over from the attorney who is doing the questioning. So let's assume our attorney in this case is Mr. Shaw Hobbs. Remember, labeling the attorney, we use the surname. So in this case, the title we write, so the first title we indicate, in the speaker's name field will indicate title. In the first state, we indicate if it's the mode of examination. You know, we have got like 6 modes of examination. We have got direct examination, we have got redirect examination, further examination, further direct examination. There are 6. We did cover them in our initial season. So the first step, the title in the transcript side will indicate the mode of examination. Now, in this case, the example I was giving, the taking attorney is the one who does the first examination, and we refer to it as direct examination. The second examination after direct examination, we refer to it as cross-examination. Examination conducted by attorney of the opposite side. So, because the direct examiner, the direct attorney has already conducted the first examination, now we are crossing over to the second examination, the attorney of the opposite side. Now we'll be having cross-examination. Now, our example was our example of the attorney conducting the cross-examination was Luke Shaw. Now we refer to him as Mr. Shaw as the surname. Shaw as the surname. So immediately after the first title, remember the first title we indicated, title, cross-examination. Below it, another title. The transcript side, Mr. Shaw. You have to indicate the mode of examination and the attorney who is undertaking that examination. Immediately after that, you continue with your QA, because immediately after reintroduction, Mr. Shaw, who is our example attorney, will continue questioning the witness. The witness in the reintroduction, it doesn't change because we only have one witness who is being questioned, the key witness. Another time in which we are going to do a reintroduction is when there is a disruption of the QA format by a colloquy format in what is more than 4 lines. If it is 2 lines, it's okay. Like like an example of that, attorney asks her questions, then in between there is an objection. That's a colloquy format. That's a single line. Example in this case, our cross-examination attorney tumesema is Mr. Shaw. So let's say Mr. Shaw starts questioning the witness, and our taking attorney is Mr. Luke. Then Shaw starts to question the witness, but Mr. Luke feels Shaw is overstepping his mandate to question the witness. He will come and interrupt, and he will overstep and says, no, objection of object to form, or I object the form of question asked by the attorney. That one is a colloquy because they are not talking about the main matter of the case. They are not asking question. It's not a Q&A format. In the presence of a court, in the presence of the judge will either say he objects or objection overrules. Those are 2 modes of colloquy example. But in the event an attorney was questioning a witness, and within the process of questioning the witness, the attorney says that he needs to go for lunch. And so in this case, Q asks, were you there at the presidential scene? A, yes. Then the next question, the next ought to be question, Q says, I feel so hungry, I need to break out for lunch. So in that case, the naming format will change. We'll refer to it as Mr. Hobbs says, I need to break out for lunch. Below it, the witness will abide by that. Remember, when the witness says something which is irrelevant to the matter in question, the naming pattern will change. So in this case, he won't reply to it as A. We won't label the witness as A when he replies to the suggestion of the attorney. He will say, yes, I'm also hungry. When he says he's also hungry, he's not replying to the questions which are expected to be answered by the court. He's talking about something which is irrelevant. So we'll refer to him as the witness. Then the attorney comes into play and say, okay, we've heard you. We are going to break for lunch. The time is 10:30 a.m. or blah, blah, blah. That is 3 lines or more. So in that case, before they return and continue the Q&A format, we need to do an reintroduction, at least to indicate within the transcript and indicate to the viewer that the examination was being done by an advocate who was so and so, and the mode of examination was either direct, cross, further direct, further cross, or redirect, recross. And the other file which has been confusing you guys are the prison calls. Prison calls they are in the format of the legal files, but they are not truly legal files. Most of the conversations are in colloquy, because no question is being asked to determine a case. So normally the prison calls happen within the prison setup. Remember, the legal files are within a court setup. The prison files, the prison call files, they are within the prison files. These are when the prisoners are calling their loved ones, their relatives, out of the prison station. The format is in the colloquy format of legal files, in which this case, the prisoner will be accustomed the name Mr. or Mrs. Remember, in legal files, the only people we refer to them as Mr. and Mrs. with their surnames are the legal attorneys, whereas the witness to refer to them as the witness. The prison call, all the individuals, all the participants within the prison calls, we refer to them with their names with the initial of Mr. or Mrs. For our next videos, you will get more on prison calls, how you can research on that, how we can do an introduction in case there are more than 2 prisoners who are having prison calls. Let's meet next week. Please don't forget to click subscribe in the subscribe button. See you next week as we focus more on the prison calls. Thank you.